You're listening to continuing coverage in the suitcase murder, the trial of Sarah Boone, from the Hidden Killers podcast and True Crime Today. Now, back to the courtroom.
You all may be seated. Thank you. Defense, any motions?
Judge, we do have some motions, but my client needs a comfort break.
Okay.
If we could do that, because it may be fairly lengthy.
Agreed. Let's go ahead and take that break. Court's going to be in recess for 10 minutes, and then we'll pick up any motion practice at that point in time. Court's going to be off the record. Thank you. We're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. Appearances for the state.
Yes, sure. On behalf of the state, William J. for the state.
Defense.
James Owens for Ms. Boone. Tony Henderson.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Do we have any motions?
We do, Your Honor.
You may proceed.
If I may approach the podium, Your Honor.
Yes, sir.
Your Honor, at this time, the defense would move for a judgment acquittal. I'm going to start with just a real quick couple of comments, Your Honor. We know that JOA motions have become essentially pro forma, which may be why I've been assigned this responsibility today. But in this instance, I want to make an argument that I think has some merit. I've been paying close attention to the testimony in this case, and I want to point a couple things out. First of all, we know that the court has essentially assumed the role and is assigned the role of becoming a gatekeeper in this matter. We know from the testimony that's been presented in this matter that not only did law enforcement, but also the Office of the State Attorney had knowledge of these parties prior to the event having occurred. And despite that, the state has proceeded with this prosecution based upon a criminal information as opposed to having taken it to the grand jury. That kind of places the court in a special position to evaluate the nature of the evidence that's been presented. I want to focus on the second-degree murder allegation. And one thing that occurred to me while watching the evidence as it was presented, watching the videos, particularly of the interrogation, was part of the dialogue between Ms. Boone as well as Detective Scott Lowen at the end of the interrogation. And I'm going to paraphrase. I apologize. I should have written this down verbatim. I did not. But she's advised that she is being placed under arrest. Something to that effect. And her response is, "Why are you doing this?" The detective's response to Ms. Boone is, "Because George is dead."
I'm sorry?
Because George is dead. That's not enough. It's not enough to support a second-degree murder, prosecution, conviction, or should it even be enough to allow this matter to go to the jury? Now, there are three elements of the second-degree murder information. The first is that the victim is dead, that Mr. Torres is dead. We stipulated to his identity. There has been no argument to the fact or the idea that he died in this incident. However, the state also has to show that it was caused by a criminal act and that the act was imminently dangerous and demonstrated a depraved mind. Now, the fact that it was imminently dangerous, I think, is belied by the fact that Jorge Torres voluntarily entered the suitcase, albeit under the influence of alcohol. But the perception of dangerousness that's attributable to the victim, apparently he did not perceive it to be a dangerous or an imminently dangerous situation in having entered the suitcase, possibly because of the influence of alcohol on his capacity to make decisions, should necessarily be attributed to the defendant as well. But I also want to focus on the depravity issue, which the state must prove, and pursuant to the jury instruction in this matter, depravity is is made the equivalent of ill will, hatred, spite, or evil intent. And that's not enough. Not only does the state have to show depravity, but it has to show, because it's in the conjunctive that the act demonstrates an indifference to human life. The state has presented testimony and argument in this matter, not argument, but testimony that in fact George Torres was suffering. Suffering does not equal hatred. It does not equal ill will. And even if they were to establish negligence, that's not homicidal. We know that suffering is something that the courts have been very, very cognizant of and very sensitive to. We know it from the field of capital punishment and incarceration. The idea that somebody suffers is not in and of itself homicidal, nor should it support the idea that there was indifference to the life of George Torres by Sarah Boone. Was she angry? I think there's clear evidence that she was angry. But that's not hatred. And that's the element that has to be proven here. And I don't think that there is prima facie case that in fact that she demonstrated hatred so much as she demonstrated anger. Doesn't establish a prima facie case of second-degree murder. It's for those reasons, Your Honor, that I think that this matter should be, the motion for JOA as to second-degree murder should be granted, and this matter should be allowed to proceed solely on a manslaughter charge because, in fact, they have not established prima facie elements as required by law. Thank you, Your Honor.
Thank you. Response.
Yes, thank you. Standard at this time is just a prima facie case. Whether any trier of fact, in taking all the facts in the light most favorable to the state and the inferences drawn from them, establish the elements of the crime. There are 3 elements to this crime. George Torres is dead has been established by a prima facie case. The death was caused by the criminal act of Sarah Boone that has been established. There was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. It's not Ms. Boone's subjective statements on February 25th. I had no idea you could die from being zipped into a suitcase for 13, 15 minutes before she goes to bed. 2, is done from ill will, hatred, spite, or an evil intent. We heard what she said. The 2-minute video starting at 11:12 p.m. 45 seconds should be linked in Merriam-Webster's digital dictionary for the definition of depraved mind. Fuck you, I don't care, laughing is of such a nature that the act itself indicates an indifference to human life. Sarah, that's my name, don't wear it out. Judge, there's no question that a prima facie case has been laid. In addition to the 2-minute video and then the 22-second video 11 minutes later, we also have the defendant's inconsistent statements that she has made in regards to these events, and therefore we have that factual issue for the jury to decide. She made statements on the 911 call and to law enforcement both on the 24th and 25th that I have no idea what happened. I just went to sleep, everything was good, and then when confronted with her video on the 25th, we see that there are 2 distinctly different sets of statements that were made. So this is sufficient at this stage in time for a jury question. Thank you.
Thank you. Any other additional argument, Mr. Beck?
No, Your Honor.
All right, thank you. Thank you both for your arguments. The court, in viewing the light most favorable to the state, the court finds that the state has presented competent but rebuttal evidence to establish each of the elements of the charge contained in the information to the required level of a prima facie showing. As such, the defense's motion for a judgment of acquittal is denied. Defense, do you intend on putting on a case?
Yes.
Okay. Ms. Boone, I have a couple of questions to go over with you.
Judge, if I may.
Yes, sir.
In a normal criminal trial, My position has always been to put on the defendant last. Call whatever witnesses, put on the photographs, and then the client would be the last person to testify. Because of the nature of discharge and our defense, self-defense and that of spouse, we understand that we have to put on her first, Sarah first, and the court to then consider whether or not we've established enough evidence for self-defense instruction. So she's going to have to be going first as the witness. I'm going to need a few moments with her based on everything that's going on and based on that denial of that motion for judgment of acquittal, to just go through it again, because I know you're going to ask the colloquy about all that. So I'm going to need a few moments with her. I don't know if it's 10 minutes maybe for the 4 lawyers, to meet with her. I don't know if we can do it here or maybe back there, but just a short meeting.
Sure, I'll give you that opportunity, but before you do that, ma'am, I don't want to go into any specifics of any conversations that you've had with any of your attorneys in this case. Mr. Owens has identified for the court his normal practice of calling a defendant last in a criminal case. In this case, he has advised that he wants to call you first. Without going into any discussions of any strategy that you've had with your attorneys, do you understand the strategy that Mr. Owens and your team will be utilizing in your defense?
Yes.
And are you in agreement with that strategy?
Yes.
All right. Counselor, you can have that opportunity to speak to her. The court will remain here. I don't know if they can, Officer Jones, can we let them back to have that conversation? Okay. All right. You can go back and have that conversation. The court will remain here. We'll be in a short recess for approximately 10 minutes. Thank you. All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
David Kester on behalf of the state.
William J. for the state.
Defense?
James Owens from Ms. Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same black blazer and dark blue blouse from this morning. She is in custody, however, not wearing any restraints, so she'll be able to stand when our jury enters, and if she is called to testify in this matter, she will be able to walk to the witness stand. Ms. Boone, I have a couple of questions to go over with you. Similarly to our conversations earlier today, I don't want to know about any of the substance of any conversations you've had with your attorneys, just whether or not you've had certain conversations. So far, you've been present throughout the entire trial process. You've been seated at counsel's table. You've had the opportunity to observe the evidence presented by the state, as well as the direct and cross-examination of the state's witnesses. Are you satisfied with your attorney up and until this point?
Yes.
Now, I'm going to ask you some questions again about specific conferences and conversations you have with your attorneys. I don't want to know those specifics, just whether or not those things have been had. Have you had the opportunity to discuss with your attorneys whether or not you would like to testify as a witness in this case?
Yes.
Do you need any additional time to discuss that matter with your attorneys?
No.
Have your attorneys discussed with you the potential benefits and potential harms of testifying as a witness in this case?
Yes.
Are you satisfied with the advice from your counsels?
Yes.
Do you understand that attorneys can make most of the decisions about trial strategy? They cannot determine whether or not a defendant testifies or not. Do you understand that?
Yes.
Not even the court can interfere with the defendant's right to make that decision. Do you understand that?
Yes.
Do you understand that it is your decision and your decision alone?
Yes.
While counsel can give you advice on whether or not it would be wise for you to testify in this case, do you understand that you can ignore counsel's advice because the final decision is yours?
Yes.
Do you understand that you have the right to remain silent?
Yes.
Did you hear me explain to the jury at the beginning of the trial how the right to remain silent is absolute, and the fact that a defendant did not testify cannot be considered as evidence of guilt or influence their verdict in any way?
Yes.
Before a jury begins its deliberations, the court will read another jury instruction if you decide not to testify. This instruction orders the jury not to consider your silence as evidence of guilt or to consider your decision at all. Would you like me to read that instruction for you at this time?
Yes.
It is instruction 3.9a, entitled Defendant Not Testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by her decision. No juror should ever be concerned that a defendant did or did not take the witness stand to give testimony in the case. Do you have any questions about this instruction?
No, Your Honor.
Do you understand that if you choose to testify, you are waiving your right to remain silent?
Yes.
That means once you begin to answer questions, you have to answer all questions unless I instruct you not to answer a question. Do you understand that?
Yes.
You cannot pick and choose which questions you want to answer and not answer. Do you understand that?
Yes.
Do you understand that if you refuse to answer any questions, the court can impose sanctions, such as holding you in contempt, striking your entire testimony, and instructing the jury not to consider any of your testimony? Do you understand that?
Yes.
If you choose to testify, you will also be subject to cross-examination and impeachment. That means the state could ask you about any prior felony convictions or convictions for crimes of dishonesty if you have any such convictions. If you have any such convictions, the questions will be limited to whether you have such convictions and the number of same. Do you understand that?
Yes.
Are you aware if you have any such convictions?
Yes.
State? Are you aware of any felony convictions or convictions for crimes of dishonesty?
No, I believe she's answering in the affirmative. She's aware that she doesn't.
Okay, so you have no such convictions. Okay, thank you for that clarifications, ma'am. As there are no convictions, and that number is not in dispute, the state will not be permitted to inquire into those matters. Have you had enough time to discuss your decision to testify or not testify with your attorneys?
Yes.
Again, do you need any additional time?
No.
Has anyone forced you, threatened you to get you to testify or not testify in this case?
No.
Has anyone made any promises to you to get you to testify or not testify in this case?
No.
Are you satisfied with your counsel's advice so far in this case?
Yes.
Are you making this decision freely and voluntarily?
I am.
Did anyone force you, threaten you, or coerce you to testify in this case?
No.
Would you like to testify or not testify as a witness in this case?
Testify.
Okay. And ma'am, similarly, after you've had the opportunity to converse with your lawyers again, I want to confirm that you're on board with the strategy that they've utilized in your defense in this case,
Yes, I understand.
including calling you first.
Yes.
Okay, all right. I want to remind you, ma'am, that you can change your mind. You just have to let your lawyers know before the jury comes back in. Do you understand?
Yes.
State, anything else we need to address?
Just that the law of the case is that there should be testimony from the defendant of an overt act that particular day before there is testimony about reputation evidence, prior instances of violence, or any of the ancillary things that come with self-defense.
Holland case speaks for itself. Anything further?
I do want to talk about that, but as it relates to her right to remain silent or testify, I have nothing about it.
Okay. Then what do we need to address with regard to Holland?
Well, I've got three issues. One is Holland. The other is I've got these gloves. My client and I would like to take a few moments to look at the suitcase and to look at the bag. And then the third thing is that the state had filed that motion for the in-camera hearing. I don't know. Maybe we need to hear that before she testifies.
Court's not going to address that at this time.
Okay.
We'll address that later in the proceedings.
So the two things, number one, of course, I've got a lot of photographs about the prior violence that Jorge Torres committed on Sarah Boone, and there is a dispute about whether or not I have to establish an overt act that she responded to, that she considered an imminent threat, and that she took evidence, or she took action to either block or physically restrain Jorge Torres from committing an act of violence on her. But Judge, if you'll remember, during the 2-hour interrogation, the officers make mention that they are aware of the prior incidences of violence. So I believe the door has been open, that I can go into that based on those statements by the two detectives
If you remember, they introduced this 2-hour video. She says, he comes at me all the time. I think eventually Sarah Boone realized that they had her phone and they were going to see pictures, they were going to see videotapes of evidence that Jorge Torres committed acts of violence on Sarah Boone. I think at that point she changed her tone about George. She was trying to protect George, but then she realized she would have to disclose some of the acts that had been committed on her by Jorge Torres, and so she did talk about him coming at me, and we've had issues before, and the officers gave, I can't remember exactly what they said, but yeah, we're well aware of, I don't know if they said the prior acts or we're aware of the domestic violence, whatever the case may be. I submit that opens the door. That was during their case in chief. They chose to play that entire video. And so I think I can talk about the prior bad acts before the event in question chronologically. And I've got a bunch of photographs that go into physical evidence of her injuries as a result of George's violence.
Okay. Response, if any.
Judge, we're asking for the court to maintain its ruling. We already read an instruction that the police are allowed to tell her things to try and get reactions from her. She affirmatively denied there was an overt act that night to the police. And the court, in its ruling pre-trial, I'm trying to get some guidance on this, reviewed Ms. Boone's most recent statements on the matter, and there is no overt act thus testified to. So we are hopeful that we will maintain that ruling, and I don't know how it prejudices her or her team in any way to establish an overt act on February 23rd, 2020 before we go into reputation evidence, prior instances of violence, or battered spouse syndrome evidence.
Any other further argument, Mr. Owens? No. All right. I don't find that the officer's statements are character evidence, and you're looking for specific instances of conduct which are going to be utilized for those specific purposes for reputation or violence to establish the fear component that the case law speaks about. Florida Supreme Court decision in Holland is clear that that overt act needs to be established before any of that evidence is submitted. I don't find that it's an opening of the door, and I'm going to rely on what the Florida Supreme Court has told us to do.
Judge, I've got to get the clerk to mark some photographs, and then my client and I need to take that suitcase out of that box and inspect it, play with the zipper a little bit, and then also take that bat out of that paper bag and inspect it before she testifies.
Any response?
I'm just confused why we haven't utilized the nearly half an hour or more that the court has been off the bench to get these photographs marked. The defense team has been on board for quite some time. They did not request a second evidence view of the physical evidence that Ms. Boone already had an opportunity to do while she was pro se. It's 11:25. We need to try the case.
Judge, I think that she had that evidence view, I think, with Billy Lane. I believe that was the day after I filed my notice of appearance, or maybe it was the day I filed my notice of appearance. I don't remember exactly, but it had already been previously scheduled. I was in Milton, so they went ahead and did it that morning, I believe at the jail. I believe the evidence.
Any particular reason why it hasn't been done in the last 45 minutes?
Because
when I sent my jury out?
I've been meeting with my client about her rights to testify or not, and other related matters. So in terms of not giving her this evidence?
In terms of anything that the state just discussed?
I've just been busy with my client.
Okay. How much time do you need in order to pre-mark these exhibits and look at the baseball bat and the suitcase which have been entered into evidence?
I would think 15 minutes.
I'm very concerned because it is 11:25 and I discharged our jury some time ago, and I don't want to be in a position where we have to break in the middle of testimony.
May I suggest that we just take an early lunch? It's 11:30. Let's take an early lunch. We've got witnesses coming this afternoon anyway. If her testimony ends before 5, we've got 1 or 2 witnesses that are here, and then I believe tomorrow is Wednesday. We've got Dr. Brannon. It's going to be here first thing Wednesday morning, and then I believe Dr. Harper's not going to be here till Thursday morning. So we're going to have a little gap in time unless we've got to put on several officers about prior acts and all that. But I think for purposes of this, Judge, in the abundance of caution, I feel like I need to go over this evidence with my client before she testifies. And I have not had a chance to view that evidence other than seeing it here today. But I think I need to do that with her before she testifies.
Okay, can the parties approach for a moment? It is 11:35. Councils have matters that they need to address with Madam Clerk for the pre-marking of exhibits and along with the review of the suitcase and bat which were previously entered into evidence. I'm going to bring based on the agreement of the parties, I'm going to bring our jury panel in at this time, release them for lunch, give them a similar instruction to the instructions they've been provided earlier, and we will commence promptly at 1 o'clock this afternoon. State, any disagreement with the battle plan so far?
No, sir.
Same question, Mr. Owens.
No, sir.
All right, let's go ahead and stand, bring it back in our panel.
Jury entering.
State, do you recognize our jury?
Yes, sir.
Defense, do you recognize our jury?
Yes.
I thank you all can be seated. Members of the jury, again, once you're seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions. All right, thank you very much. Thank you for your patience. Matters with counsel took a little bit longer than we anticipated. We're going to take an earlier break today. It's 11:35. We anticipate the defense putting on a case this afternoon, and we don't want to get into it and then have to break a half an hour into it. So we're going to go ahead and take that break at this time. I'm going to give you a similar instruction as I've read to you over the last couple of days. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have any discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. With that, members of the jury, I thank you for your time and your service and your attentiveness, and we'll see you at 1 o'clock this afternoon. Thank you.
Jury exiting.
Y'all may be seated. Thank you. State and the defense, if you could please review those items, and please mark every defense exhibit at this time with Madam Clerk, and I will see you all to commence promptly at 1 p.m. Court's in recess. Thank you. We are on the record.
My client's not here either.
We'll wait for her. That's fine. Just hang out for me. We're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state.
David Castro on behalf of the state.
William J. for the state.
Defense.
James Owens for Ms. Boone.
Connie Henderson for Ms. Boone.
Ms. Boone is seated at counsel's table, wearing the same black jacket and blue blouse from this morning. We will be standing when our jury enters. She is in custody but out of any restraints. As she is testifying first, once we bring in our jury, she will walk to the jury box and be sworn in front of the jury. State, are we ready to bring in our panel?
Yes, Your Honor. I was able to get the redactions done. I put a disc on Mr. Owens' notebook there. Has the case number on it and 3 black dots in Sharpie, just so that a random way of saying what it is.
Excellent. Appreciate it. Thank you for getting that done over the lunch hour. Defense, are we ready to bring in our jury?
I've got a couple of issues.
Yes.
Number one, Kevin Beck is working on.
Let the record reflect that Mr. Beck has appeared.
For the record, I'd like to make 2 points about this issue, about whether or not I can bring in evidence of prior acts, prior bad acts, prior to the overt act. And there's 2 reasons that I believe I should be allowed to do so. One is, Judge, in that 2-minute video, Sarah Boone makes a statement, "That's how I feel when you choke me." And then some moments later, "That's how I feel when you cheat on me." And she's angry at him, and she's talking to him. She's talking to him in an intoxicated state, and she's expressing her anger and why she is angry. And I ought to be able to elaborate on what that is that she's angry about as it relates to when you choke me. That's my first motion.
Okay.
The second one is, Judge, on this.
Before you proceed with the second, is the second intertwined with the first?
No, I mean, it's a similar argument, but related to something else.
Okay, response.
Judge, I don't disagree that they should be able to bring that in once they've established an overt act that is imminently dangerous to an objectively reasonable person. I believe that's the law in the home.
Any other further arguments, sir?
Not on that issue.
Motion's denied. Court, again, is going to rely on the Supreme Court's guidance in these situations based on Holland 916 Southern 2nd 750 at point 760 through 761.
My second argument ties into what he just said about what a reasonable person would do under the circumstances facing an imminent threat, whether a reasonable person would perceive the overt act on the part of Jorge Torres that was witnessed by Sarah Boone. Would that be perceived by someone as a imminent threat? And to some degree, you have to understand the history of Jorge Torres and Sarah Boone. They were together 3.5 years. They were engaged, but there had been a history of violence. And from the evidence that's been presented, facing the circumstances in total, if you take what she said at various times, you would understand that she became concerned when he came back from Publix with that second bottle of wine, because she knew when Jorge Torres gets to a certain level of intoxication, he gets sad, he gets moody, and eventually he gets belligerent, and sometimes he can be violent. So she knew when he brought home that second bottle of wine that it was not going to be a good night, and she tried to keep him occupied and tried to keep his mind off of his troubles, because she knew that if he reaches a certain level and is dwelling on his hardships, that he will react to her in a violent way. So she had that state of mind with that understanding of her history and his history in his overt act, which she's going to testify to, coupled with the fact of her state of mind based on her past experiences with him in that intoxicated state and the fact that he is violent. So she was hypersensitive to danger and fear. And I think that ought to be allowed in as part of her collectively an overt act. So it was culminated by his state of intoxication coupled with his overt act created the well-founded fear for her to block the attack, to self-restrain or physically restrain Jorge Torres in the suitcase, to actually use the bat to prevent him from getting out of the suitcase because she knew she was going to get attacked.
And the basis of the opinion of about to be attacked is predicated on the prior incidences of violence, correct? Based on
Well, there's an overt
knowledge.
act committed by Jorge Torres, but she was heightened because she knows when he gets to that level of intoxication in that scenario, and that's an issue.
So I need clarification. What is it that you're asking me to do?
For me to be able to elicit from Sarah Boone that she was concerned once that second bottle was brought, and that's why she tried to placate him over the course of the evening, and that's why she had a heightened sense that he was capable, Judge, due to his degree of intoxication, that he may act violently towards her. And the problem is, a lot of the problem is, Judge, he doesn't remember battering her the next day. That's part of the reason that she videotapes him and photographs him. She starts to document what happens so that she can show him. She loves the man. She adores the man. She wants to marry him. She wants a life with him. But she's tired of being beat on, and so that all ties into her behavior, her sense of nervousness at that point. The reason she was so confident during that 2-minute video is because she knew, okay, this is my chance. He can't get to me. I can tell him exactly what he does that bothers me, that hurts me, and how I feel. And so that's all tied together with then he starts to try to get out of the suitcase, and she reacts the way she does.
Response.
We held these arguments already. The court has ruled there are no new arguments being made. The court understands exactly what Sarah Boone, the defendant, said to Dr. Werner on October 2nd. The court knows exactly what the defendant said to Dr. Harper over the period of a number of months and years, and there was no overt act. The overt act has to be something that is objectively reasonable to cause a reasonable person to believe there's an imminent fear of great bodily harm or death. What the testimony is not that that's what has occurred, that there's her new testimony is this generalized fear, but you've already read that and you've already ruled on that. And I'll just remind the court that her previous testimony is, it's all fun and games, we're laughing, I zipped the suitcase shut, we're still both laughing, it's funny, and then the decedent says, I can't breathe, and then she flips a switch, gets angry because it reminds her of all the times before where she is asserting that the decedent made her feel like she couldn't breathe. And then that's when she starts beating and shuffling the suitcase so much that it flips over and hitting him with the bat. We've covered this ground. Aggravated assault, aggravated battery, 2 independent forcible felonies. She's committing false imprisonment. She is the initial aggressor after there being no overt act. She can't start it and then say, well, I'm in fear of retaliation, because that's what her testimony was, is once I started doing these things, once I wouldn't let him out of the suitcase, I was afraid he would come out and harm me or kill me. Well, Judge, if I pull a gun on you and I say, give me everything you own on you right now, and then you in turn pull a gun on me and say, bam, 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 and shoot and kill me, and I shoot, let me strike that, you pull a gun on me to defend yourself and then I shoot and kill you, I can't assert self-defense. I can't say, well, Judge Kranick pulled a gun on me and I was in fear of death, because I was the initial aggressor. I was committing a forcible felony. That's the facts of this case here, according to her previous testimony. And the state concedes if she wants to change her testimony again, that's one thing, and then we'll cross that bridge when we get there. But if she testifies as she previously has, the court has already ruled there's no overt act, and you've read the transcripts. You know what she has said.
Judge, she hasn't testified. She hasn't testified. Dr. Harper's testified. Dr. Warner's testified.
They have not testified. They've given depositions.
Well, given depositions, but she hasn't testified about the act in question. She hasn't testified about the event in question. She had consultations and evaluations by Dr. Harper where they had discussions that Dr. Harper could relate in her testimony. Dr. Warner can say what was said during the evaluation. Again, both of those were not recorded. There may be disputes. I disagree with his characterization of that assessment. But it's up to Sarah to tell the truth here today. She's under oath. She's under oath today. She's got an obligation to tell the truth. If he thinks she's made prior inconsistent statements, it's up to him to impeach her with those inconsistent statements.
To the extent that you are requesting permission to go into presumably and seemingly prior bad acts, vis-a-vis, he got the wine, and I know what happens when he gets it, and everything that follows from that, those are bad acts. That is character. And the Florida Supreme Court has provided guidance and circumstances, specifically in Holland, on what needs to be done. You're attempting to provide information that the defendant was apprehensive of the victim at the time of the homicide by virtue of the wine, etc., as you've proffered. That's bad character evidence that you're going to be bringing in. Historic bad character evidence. This is what happens when he drinks. This is what happens when I don't placate him. This is the situation that I find myself in, which inevitably may dovetail into prior incidents of abuse. That's all prohibited character under 404, 9404. And the carve out for that is if a overt act is established. It's not a subjective standard, it's an objective standard. The jury instruction, 3.6F, identifies it being an objective standard, and the Akendo case specifically tells us that it's an objective standard. In Akendo, the second DCA in 2023 stated, the conduct of a person acting in self-defense is measured by an objective standard, but the standard must be applied to the facts and circumstances as they appeared at the time of the altercation to the one acting in self-defense. I'm going to rely on Holland. Holland is the law of the land. It is what the Supreme Court has told us to utilize. That's what I will be relying on. The overt act has to be established.
Ms. Boone, do you understand that?
I do.
Okay. Anything else?
We cannot talk about any prior bad acts or anything of that nature until we talk about the actual event, the attack. Correct? Mm-hmm. You understand?
Do you understand that?
I do.
Okay. Anything else, State?
Nothing.
Defense, anything else, sir?
No, sir.
All right, let's go ahead and stand and bring in our jury.
Jury entering.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury? All right, thank you. Y'all can be seated. Members of the jury, after seated and comfortable, if you could raise your hands to confirm that you complied with the court's instructions during the break. Record reflect all hands have been raised. With that, State has rested. The defense is going to put on a case. Defense, Mr. Owens, you can call your first witness.
The defense would call Sarah Boone.
Raise your right hand, please. Sworn, please. Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, ma'am, you could take a seat. And if you could, state and spell your name for the record for us.
Sarah Boone, 101077.
And could you spell your name?
SARAHBOONE.
All right, thank you very much. Sir, you may inquire.
Ms. Boone, would you please tell the jury where you were born and raised?
Atlanta, Georgia.
You were born in Atlanta?
I was born in Atlanta.
And how long did you stay in Atlanta before you moved here to Florida?
I was 3 years old, 3 or 4.
Okay. And from that time, y'all moved, you and your family, your mother and father, moved to Orlando?
And my grandparents.
Okay. Y'all all moved down from Atlanta down to Orlando?
Yes, and my 2 brothers.
Okay. And were you raised here essentially from that time on?
Yes,
And you resided here in Orange County, Florida that entire time?
yes.
Okay. And where did you go to high school here locally?
I did.
Where did you go to high school?
Edgewater.
Okay. And tell the jury, how old were you when you graduated?
I was 18 years old.
Now, I know you lost your mother and father.
Overruled.
I know you lost your mother and father in your teens and in your 20s. Is that true?
I lost my grandfather when I was a sophomore in high school, and I lost my father when I was a senior. And then my mother passed away a few years after that, and then my grandmother passed away after my mother died.
All right, so you were in your 20s when all that was going on?
Yes,
Okay. And then at some point in your 20s, you met Brian Boone?
I did, yes.
All right. And how long did y'all date before you married?
A good handful of years. I helped my family with paying mortgage and bills for the house since my father had passed away and my grandfather, so
So you worked outside the home?
I did.
Okay. Can you tell the jury when you said you and Brian Boone dated for a while? Do you remember when y'all married?
I do.
Could you tell the jury when y'all were married?
The year?
Yeah. You remember the date?
It happened to be, yes, that after my mother passed away, that he had waited to ask me to marry him because he knew it would be,
Objection, non-responsive.
Sustained.
Just answer the question if you can, Ms. Boone. Are you a little bit nervous?
a little bit.
Okay. Well, just tell the jury if you remember the date that you and Brian Boone married.
August 21st, 2004.
Okay. And had y'all lived with each other for a short time before that?
Short time.
Yes. Okay, after you married, how long was it before y'all had any children?
Gosh, 6 years?
Okay. And y'all have one son.
Yes.
What's his name?
Lucas.
And how old is Lucas now?
Lucas will be 14 years old on the 28th.
28th of this month?
Yes.
Okay. So you and Brian were married and y'all lived in Orange County. How long were y'all married?
For 13 years.
All right, and y'all divorced?
Yes.
And as part of the divorce, were y'all to share custody of your son?
Yes.
And so y'all would split days, would that be fair to say?
Yes.
Okay. At some time after you and Brian split up, did you meet Jorge Torres?
Yes.
All right, could you tell the jury how you met Jorge Torres?
I met George when I decided to buck up, I guess, and was tired of trying to patch things up with my ex-husband. And I decided to go one day for a walk across the street and go have a beer by myself and sit and people watch just to get out of my house and a change of scenery.
All right, now is this your apartment?
No, this is the marital home.
Okay. Where is that marital home?
Winter Park?
You're no longer living in that marital home?
No.
Who lives in the marital home?
No one. It has been sold.
Okay. So So you met George Torres before you got the apartment?
Yes.
Okay. And you met him at a bar across the street from the marital home?
Yes, we had a mutual friend there.
Were you introduced?
Yes.
All right. How did you and George get along when y'all first met?
Very well. It was strange how quickly we hit things off and had so much in common, and I never thought that he would be interested in someone like me, and I just couldn't believe that he was actually interested in me and said a lot of nice things, and 1 hour ended up being 4 hours from when we had first met, and then we would always have something to talk about.
Why couldn't you believe that he would be interested in you?
He was very handsome. He was very funny. He was smart, and I would show up in workout clothes and disheveled hair, and I guess I kind of felt broken from being in the process of the divorce that he knew about. But then one of the things that we could relate also was the fact that he was here in Florida because he had just been divorced from his second wife. So that was another topic that he and I could compare notes on.
So eventually the divorce was settled. Did you get your own place?
Yes.
Is it fair to say that after at first you lived in your parents' home, correct?
Yes, until I was married.
And then you moved directly in with Brian?
Yes.
And then y'all lived in the marital home, correct?
Yes.
And then you got this apartment.
Yes.
So that was the first time in your life that you actually had your own place.
Yes.
And what was the address?
4748 France Court, apartment number 3.
And what city is that in?
It's in Winter Park.
How far is that from here?
20 minutes?
Okay. So you got that apartment, and initially were you by yourself?
No.
All right, tell the jury.
In the almost year, about 10 months of separation from Brian, my ex-husband, that is the time when I met George. And my ex-husband was trying to buy me out or force me out of our marital home, and I needed to find somewhere to live. And
So did you and George agree to rent the apartment?
yes, I needed extra income. We could not afford it, just on my own.
You were receiving some income from the marriage settlement, were you not?
Yes,
So you did have consistent monthly income coming in from the marriage settlement,
for the most part, yes.
but you needed more to live.
Yes, to pay the bills and for rent.
So did you and George have some agreement?
We did.
All right, what was the agreement?
The agreement was that if I decided for he and I to live with one another, because it would be under my name, that he would help with the monthly bills and on a regular basis, where it wouldn't be something that I would have to argue with him about. It would just be an automatic, make sure that everything's paid first, and then from there, hopefully have some fun with it.
Okay. So I understand from that point on, would it be fair to say that y'all saw each other on and off for about the next 3.5 years?
No, I would consider us a couple. At some point, he asked me to marry him.
Okay. But y'all did have times where he left and went to live with his parents?
Yes.
Is that fair?
Yes.
And there were times where there was an understanding that y'all were going to break up?
Multiple times.
Okay. All right. So, again, on again, off again.
Yes, this was actually before we had our apartment. That was, I guess, our dating phase.
Okay. So y'all were together for 3.5 years. Is that fair?
Mm-hmm. Yes.
And y'all had actually agreed to marry?
He had asked me, yes, a couple of times to marry him, and one time I agreed to yes.
Okay. Now, I want to get directly to the date of this event so that the jury can hear your testimony. All right, so tell us, I believe the date is February the 23rd of 2020. Explain to the jury that whole day, from the time y'all got up, the whole thing.
Approach. Objection's overruled for now.
Now, Ms. Boone, let's just, instead of one long speech, let me break you up over the course of the day. So, do you remember the date of February 23rd, 2020?
Yes.
Do you remember getting up?
Yes.
All right, just tell the jury about that morning. What y'all did that morning. What you and George spent the night together at the apartment.
Yes, at that point, he was living there.
Yes. So y'all slept in the bed together, upstairs, February, so you would have gotten up, y'all would have gotten up that morning, February 23rd of 2020.
Yes.
All right, tell the jury what happened when y'all got up.
He was already downstairs, and I went downstairs, and he wanted to start the day off by drinking because it was a day off from his job. And I talked him into cleaning and tidying up the house for a sense of accomplishment. So that is what we did for however long that it took. So we did tidy up the house and got everything in order, and it was kind of a reward, I guess, to be able to sit and enjoy ourselves and sit on the back porch.
All right, what do you mean by cleaning up the house? What did y'all do?
We swept and mopped. We folded some of the laundry. I know that we did the dishes, emptied the dishwasher, just general run-of-the-mill tidying up.
And did you have your son coming the next day?
Yes, that was one of the reasons why we were able to do that.
What was the arrangement you had in terms of the next day would have been your day to pick up your son from school?
Yes.
What time would you pick Lucas up from school the next day?
I believe his school ended at 3 o'clock.
Okay. So you would have been responsible to pick him up, and he would be spending the night with you that night?
Yes.
So you wanted to have the house nice and clean?
Yes.
How many bedrooms are in the home?
2.
And you and George had one bedroom?
Yes.
And who had the other?
Lucas.
All right. Is that exclusively his bedroom?
Yes.
All right. So how long would it have taken y'all that morning to clean?
I don't really remember what time we woke up, but maybe a good 2, maybe 3 hours.
Okay. And would it be fair to say that you and George both smoked cigarettes?
Yes.
And would it be fair to say that you and George both drink alcohol?
Yes.
All right. So at some point, y'all finished your chores,
Yes.
right? And then y'all were going to enjoy the day.
Yes.
All right. What was the plan?
It was just kind of, we've got the day to ourselves. Let's just kind of relax and go with the flow.
All right. Did y'all make a decision that y'all were going to start drinking?
Yes, we had a half of a bottle that was already in the refrigerator, and I did not want to go out afterwards. I, again, had Lucas coming the next day, so we went over to Publix to purchase another bottle of wine so we could not have to go out later on that evening.
Now, you were here in court when the state played the video of you two and the Publix purchasing the bottle of wine?
Yes.
Is that what you're referring to here with the jury right now?
Yes.
Okay. And that was around noonish?
I believe so, yes.
Okay. Had y'all started drinking the leftover bottle before going to the Publix?
No.
Okay. So, y'all bought a bottle of wine?
Yes.
All right. And how did y'all get to Publix?
My car.
How far is Publix from your apartment?
5 minutes.
How would you get there from your apartment?
What do you mean?
Did you have to go across any major highways, or is it right there?
You just come out of our apartment complex and you do a little U-turn and then you come up and it's right in that complex.
Okay. But it's easier to drive than to walk?
Yes.
Okay. Now, I know at some times y'all would simply need cigarettes and it was in walking distance. Can you tell the jury about that?
Yes, there was a AutoZone convenience store with, in the same, I guess, parking lot of our townhome, our complex, and it was just a straight shot from our apartment to a back gate, and you could get right into the convenience store from right there.
Okay. But y'all went over to get that bottle of wine around noonish, and how did y'all, you took your car?
Yes,
Did George have a vehicle?
we did not.
Okay. And how did you pay for the wine?
With my debit card?
And then y'all came back and started drinking?
Yes.
Okay, tell us what you did when you got back from the Publix.
Just went on the back porch where we usually spend our time because we're able to smoke cigarettes outside as opposed to inside. And
Is cigarette smoking not allowed indoors?
it is not.
Okay. Do you have pets?
Yes, I do.
Well, did you have pets?
I did, yes.
Okay. Were they with y'all there that day?
Yes, my dogs were with me all the time when I was there.
How many dogs do you have?
I have 2,
And just, what are their names?
Penny and Tess.
And what is the breed?
They are red Boston Terriers.
And are they both disabled?
Yes, Penny is blind and Teff is deaf.
So when y'all went out to smoke on the back porch and drink, I assume, as well, correct?
Yes.
Did y'all take the dogs out?
Oh, yes.
All right. Is there a place for them to do their business out there?
Yes, I extended our back porch for them to have a little bit of area as opposed to going from a large backyard from my marital home to our little townhome. And they would come out there and do their business, and I could sometimes I would open the gate and then walk them in the back part of our apartment.
So you and George were just going to enjoy the day together?
Correct.
Is it fair to say y'all don't have a lot of money?
Yes.
And so y'all were going to do something there in the home? Y'all weren't going out for dinner or?
Yes, we primarily, I would consider us homebodies as opposed to going out and partying and doing this and that.
Okay. And how long do you think y'all were out that afternoon outside?
A few hours.
All right. Could you tell the jury what y'all did during that time?
We have a dartboard that's out there, and we just had drinks and we're just really enjoying each other's company and talking about, things upcoming. We both were looking for a job and just kind of, I guess, encouraging and supporting and planning. And
Well, now you said he had a job. Was he looking for a job, a second job?
no, the job that he had was very unstable, and at that,
So he was looking for something new.
yes, at that time, yes.
Okay. And so during that 2 or 3 hours, would it be fair to say that y'all drank the bottle?
Yes,
Okay. So would it be fair to say that y'all were feeling the effects of the alcohol?
yes,
Okay. At some point, who made the decision to come in?
I did.
Okay. Why did you want to come in?
I felt that George needed a change of scenery.
Okay. So y'all came in, and then did y'all do anything else before he left again? Were y'all doing anything? I know y'all did some arts and crafts. What did y'all do? At some point, he went to get another bottle at Publix.
Yes, I believe it was after it was right before I believe that we had gone inside. Because he called his daughters. I was trying to encourage him to call his family.
Okay, now where are his daughters?
His 2 daughters are located in Pennsylvania,
And what are their names?
Anna and Destiny.
And how old are they?
I believe that Anna is in her 30s and Destiny may be in her early 20s.
All right, does he have any more children?
Yes, he has a son.
And what is his son?
He is in Pennsylvania also.
Okay. So part of that afternoon is y'all came in to call relatives, call family.
No, I had him call outside, just trying to, I guess, boost the mood. And the first daughter didn't answer, and I don't remember the reason I didn't speak to the second one. I believe if he did, it was just for a moment.
All right, now whose phone were y'all using?
My phone.
All right. And is that common for y'all to use that, for y'all to share that phone?
It was because George said that he didn't have a phone, so it would either be lost or given to him by his mother. So I didn't know he had a cell phone, so we would use my phone.
So it was primarily your phone?
Yes,
Okay. And you took a lot of photographs that were on that phone?
yes,
Videotapes?
yes,
Text messages?
yes,
Phone calls?
yes. He and I both on the phone calls.
So he would use it as well?
Yes,
And that phone, is that the one that was seized in this case?
yes,
All right, so y'all called his daughters, and then during that phone call period, did you also call his brother?
yes.
Okay, and which brother was that?
John,
All right, now, how many brothers and sisters does George have?
I'm going to list them if that's okay.
Okay.
It's John, Pharrell, Isaac, Mo, and his sister.
Okay. And do they all live here in Florida?
Yes,
Are they close by?
as far as I know, yes.
What about his parents?
Yes,
They live here as well?
yes,
Okay. But his ex-wives and his children live up in Philadelphia?
yes,
Okay. So you called the girls, then you called, or George called his brother.
yes.
Was that conversation that long?
No, it was not.
Okay.
More continuing coverage in the suitcase murder. The trial of Sarah Boone is on the way. From the Hidden Killers podcast and True Crime Today. Press subscribe now.